Yes.
All right. You want to call the roll so that we can see if we have a quorum?
Yes, I can do that.
All right.
Judge Christopher Kraft,
Present.
Judge J. Klein Lauderback, Judge John P. Hudson,
Present.
Judge Hugh Harris Harvey,
Present.
Linda D. Byford,
Here.
Stancil Ford,
Here.
Veronica Thornton.
Here.
Mr. Chair, I believe we have quorum.
All right. Let me say that we're doing this by phone because of necessity. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. Such determination and a recitation of the facts and circumstances on which it was based must be included in the minutes of the meeting. Furthermore, TCA 844-108A3 defines a necessity as matters to be considered by the governing body at the meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting for the Private Probation Services Council. The purpose of today's meeting via teleconference is to discuss the legal report and other normal business. There is one complaint that will require the council's action before the next council meeting. It's in the best interest of the council and all the parties to have complaints resolved quickly. Waiting until the next meeting is unnecessary and puts parties at a disadvantage by waiting 3 more months to have a proposed resolution to the complaint. While the council needs to address these issues, the physical presence of a quorum of the members is not possible at this time due to members' schedules and the expense of traveling. Therefore, the council has determined that it's necessary to allow participation by teleconference. Due to the impossibility of having a quorum of members physically present and the need to address the legal report and other regular business in a timely manner, the council believes that a necessity exists that requires this meeting be held by teleconference. Do I hear a motion to adopt this statement of necessity? So moved, Mr. Chairman. Is there a second? And then, I'm sorry, you'll need that for the neighbors and so forward. All right. Thank you. And is there a second?
I second. This is Veronica Thornton.
Any discussion? All right. Let's call the roll for the vote, please.
Judge Kraft,
Aye.
Lauderback, Judge Lauderback.
He's not here.
Oh,
Yeah,
okay.
he's not
I'm sorry. Judge Hudson,
Aye.
Judge Harvey,
Aye.
Miss Byford,
Aye.
Miss Ford,
Aye.
or Mr. Ford, excuse me. I'm sorry, and Miss Thornton.
Aye.
I believe we have a passing motion.
All right. The motion passes. Thank you all very much. Ms. Avers, you want to read the notice of the meeting?
The notice of this meeting was posted to the Private Probation Service Council website on May 28th.
All right. And we've all received electronically a copy of the agenda. Do I hear a motion to adopt the agenda? So moved, John Hudson. Is there a second? Second, Hugh Harvey. Any discussion? All in favor, say aye.
Aye.
Well, we need to call the roll. Call the roll for the motion, please, Ms. Avers.
Judge Kraft,
Aye.
Judge Hudson,
Aye.
Judge Harvey,
Aye.
Miss Byford,
Aye.
Mr. Ford,
Aye.
Miss Thornton.
Aye.
All right, I believe the motion passes. The agenda's been adopted. The first item on our agenda is the review and approval of the minutes. We've received minutes from it says December the 5th, 2014. that need to be approved. If y'all would review those.
Judge Kraft, the minutes on the agenda say the March 2015 meeting, but the copy of the minutes we received was December.
Right. So the minutes that we were sent electronically happen to be the December the 5th minutes that I'm looking at here.
Yes.
So have we been given the March minutes?
I apologize. I think I emailed you the wrong version. I'll have to move that one. Can we table this one to the next meeting?
So what I'll do is I'll just hold off. Well, obviously, we can't approve the minutes if they have been sent, so we'll just handle that at our regularly scheduled meeting in September if there's no objection. All right. There's no objection. That's what we'll do. Is Ms. Ella Richardson on the line?
I'm sorry, the next item on
the application review.
Yes,
that's right. We've got an application that's in the minutes, and you want to speak to that?
Yes,
Ms. Avers will speak to that.
Yes.
All right.
We have an application from a request for council approval. This applicant wants to be the CEO of Crossroads Alcohol and Drug Association on an interim basis. She has worked in the PPS field for 25 years but does not have a bachelor's degree. She's applying under Rule 1177-01.061A for the council's consideration of her 25 years experience. She also submitted the education certificates going back to 1992, which are in the staff files, but seemed excessive to email to you. I do have them in our files and here with us. They can be reviewed upon request. I sent the application in redacted form for you to review prior to this meeting. Please let me know if you have any questions about Ms. Cabe's application.
And the person's name is?
Pamela Cabe.
Right, C-A-B-E. Does everybody have a copy or have been able to review a copy of her application?
Mr. Chairman, I've got a question, and it may be obvious, and I may just simply be overlooking it. This is John Hudson. Is this a private probation council entity? When I look at the letter, there is some reference to handling violations and signing fines for probation requirements, but I don't see a lot there that really pertains to probation other than that statement.
Yes, this is a licensed entity.
Okay.
All right, and basically it's on our docket because you cannot automatically improve them because we have to waive the educational requirement and show that her experience will qualify her for that. Is that correct under the rules?
That is correct.
All right.
Yes, and that's why I included specifically that section in the rules.
Right. Otherwise, they would have approved. You would have approved the application, except it's awaiting our approval of the lack of the bachelor's degree in substituting experience in lieu of that.
Correct.
All right. Otherwise, everything in the application is in order. Is that correct?
Yes, all other parts of the application are complete and accurate.
All right. And for the benefit of the committee, and her experience is what?
She has experience going back 25 years with the, let me just pull the application here, sorry. 25 years with Crossroads.
To clarify, Crossroads is an already licensed entity. Their former CEO that had a bachelor's degree was ill and stepped down, and this lady had been working with Crossroads sort of as in a second-in-command capacity, and now they have voted that they wanted her to be the interim CEO, but since she does not have the bachelor's degree, she does need the council's approval to be the CEO.
Yeah, she's been serving as assistant director.
And for the benefit of the committee, we've got documents about Ms. Schaefer being on sick leave with the company and FBI check on on Pamela Cade, and she needs to serve as interim while they find someone to take Schaefer's place. Any other questions from the committee about that or discussion?
So this is
the only question that I have, this is Veronica Thornton.
Yes.
There are numerous job descriptions as to what her duties have been. I would be interested to know, do those duties, does that include 4 years of professional administrative experience as called for in the TCA?
Well, her letter includes a summary of that, and the minutes of the meeting where the Crossroads leadership voted her into it seem to imply also that she's served in an administrative role, handling payroll and that for more than 4 years.
And this is John Hudson, and I also have a question. She's applying for interim director, or she's seeking approval as interim director. Is that correct?
Yes, that's correct.
Is there any reason we can put a limitation on the time if we were to approve it? You know, you've got 6 months or 9 months or some definitive period of time that she can serve in that capacity, so it doesn't just run on indefinitely.
I don't think we have.
I mean, there's no rule addressing that specific question.
Really, I think our sole role, Judge Hudson, is to decide whether or not she qualifies as director, whether interim or not, because of her lack of the BA. And if we decide she does or doesn't, then I think it would be up to the executive branch of government, the Department of Commerce and Insurance, to monitor that and make sure that she is doing what she's supposed to do. But I'm not sure that we can put a sanction on her or qualify that. Our determination is whether or not we will substitute her experience for the educational requirement.
If she's qualified, and if she wants to stay, she stays, because we've already determined she's qualified, right?
I believe that's correct.
Am I correct on that?
I believe that's correct.
Right.
Right, unless there's a complaint filed against her or something like that, and of course that would come to us. But
right. If there's
other than that, our limited role is they cannot turn her on as director unless we substitute her experience for the qualification.
I understand.
Okay.
Right.
Are there any other questions from the committee? Any other discussion? All right. Do I hear a motion that her experience be substituted for her lack of academic degree? So moved, Mr. Chairman. This is time for forward. All right. Any second?
This is Linda Byford. I'll second that motion.
All right. Any other discussion? Call the roll, please. On the vote.
Judge Kraft?
Aye.
Judge Hudson?
Aye.
Judge Harvey?
Aye.
Ms. Byford?
Aye.
Mr. Ford?
Aye.
Ms. Thornton?
Aye.
All right. I believe the motion carries, so you are allowed to proceed with her application because her academic qualifications are deemed properly substituted with her experience.
Thank you.
Legal report.
All right, there is one case on the legal report. It is case number 2015-00593. Complaint states that she believes respondent has a conflict of interest because respondent's owner was the former county probation officer for the past 15 years at least. Complainant also alleges that probation services are a waste of tax dollars because probation companies just charge monthly fees because the probationers weren't able to pay the original fine. She has also heard of court dates getting mixed up and a lack of drug counseling for drug offenders. I have an addition to this complaint than what you were sent out. I did send this complainant a letter asking for more specific information about court dates and drug counseling to find if there was any additional violations. Complainant responded but did not answer my questions or give me any specific instances. So my recommendation would be to close the complaint.
Do you have any idea why this person that has a bee in their bonnet for the company, or since they've never been on probation with him, I don't need to know the name of the complaint, but is it another probation company, or?
No, it is an individual. I do not believe she is associated with any other probation company. In her letter back to me, when I asked for additional information, she stated that she had just learned that probation services were privatized in her county, and it seems to be she just has a general problem with that as opposed to the particular company. Though she did mention the conflict of interest, that I don't necessarily see a conflict there. Maybe the council thinks there might be. So my recommendation would be to close because there were no specific allegations.
And no prior complaints from the company?
No prior complaints.
This is Veronica Thornton. You might point out to the complainant that the probation services are not paid for with tax dollars.
Right.
Well, some people are against private prisons and private probation companies and everything. That's just the way people are. Well, do I hear a motion to recommend the closure of the complaint to support the recommendation of the department?
I so move. This is Veronica Thornton.
Is there a second?
Second. I second that. This stands forward.
Mr. Ford, you're a really good seconder. I appreciate it. Is there any discussion on the motion? All right, call the roll on the vote, please.
Judge Kraft?
Aye.
Judge Lauterbach? Excuse me, Judge Hudson?
Aye.
Judge Harvey?
Aye.
Ms. Byford?
Aye.
Mr. Ford?
Aye.
And Ms. Thornton?
Aye.
All right, motion carries. Thank you very much for your work on that complaint.
All right, you're welcome. The next issue was the discussion of additional rulemaking. We discussed this at the March meeting. At your request, I had looked into what the Department of Corrections requires for their probation officers, and I also looked at the other states, and that was the email I sent y'all this morning giving the more detailed documentation. What I had originally sent and then sent again this morning were just sort of my suggestions. Obviously, this is your council and your rules, and you can take them, leave them, modify them, however you want. They're just suggestions based on our discussion and what my research has shown. My suggestion would be to I would kind of go through each change I had proposed, and then we can discuss them in turn unless someone else has a different idea of how to proceed.
Well, let me ask you a question first. You sent these, and then you sent them again this morning, and I think they were titled corrections. And so I wanted to make sure that the same thing you sent us this morning was the same thing you sent us a few days ago.
Yes, it should be the same thing.
I just want to make sure it wasn't a correction of what you sent before, because I was trying to do that. So in our looking at all these documents you sent us, do you have the one in front of you that we're going to go over?
Yes.
Okay, and it is, I'm looking here at the bottom right-hand corner. Is it the one that says September 2005 revised? I just want to make sure we're all on the same document.
Yes.
Okay.
What I had done is I'd taken the
at the bottom left-hand corner it says September 2005 revised, and right in the middle of the page, the big paragraph B, there's an "and" at the end with a line through it.
Oh, yes.
Okay, I just want to make sure that everyone has this in front of them. If anybody needs any time to find the right document,
Judge Kraft,
Yeah.
there is one that says January 2015 revised.
Yes,
Is that not the most current one?
These are two separate chapters. One says 2015, one says September 2005. Chapter 1 is dealing with the application, registration, and fee requirements. Chapter 2 is dealing with professional conduct. I believe I'd sent both of them. If not, we can...
No, you did. But as we're going through this, I just want to make sure that we're all looking at the same document at the same time. So do you want to go through the one with that says September 05 has the lines through it, and then the other one also has lines through it on page 3 and 4. And I just want to, we're going to go through both of these. Is that correct?
Yes, that is correct.
All right. So why don't we then start with, just so everybody's literally on the same page, start with the one that says September 2005 at the bottom, and we'll go through that one, and then we'll go through the January 2015, if that's okay. All right. So why don't we start then with September 2005 revised?
Okay, so this would be the rules of professional conduct. Based on my research, I had proposed 3 additions to the first rule, duties and documentation. The first one would be D, have a written contract with each court the private entity provides services in. The written contract must meet all the requirements of Rule 1177-2-.03. I had included this because it's sort of implied in our rules, since there is a list in this 1172-2-.03 of uniform contract standards. But we'd had a couple calls, none of which amounted to a formal complaint, that probation entities didn't have a contract with the court, and that was causing a lot of conflict and confusion, because there were multiple probation companies in the court and none of them had a contract. And so that's why I suggested this. If you believe it's not necessary, we can take it out. I think it's sort of implied based on our rules already, but it's not specifically stated.
I guess one of my questions I would like to ask, this is Chris Kraft, is in Shelby County, we have 17 courts that furnish private, that appoint private probations. And is this a contract that y'all would write out, or would we, each judge, have to sign a contract, or what says with each court? I'm not really sure what that means.
It would not the council wouldn't necessarily be involved. It would be with the entity and the court. It wouldn't necessarily have to be each judge, I wouldn't think.
Then that's the reason I'm asking, because I'm one of the judges, and I would feel uncomfortable negotiating a contract with 11 private companies, you know, and there are 17 courts that handle the private companies in Memphis, and there are like 11 companies, and so I'm wondering, when we say have a written contract, who would draft the contract and who would decide what's in it? Not that we would have to, but how would that come about? I mean, I could see a situation where one company is trying to tell one judge, we'll charge less for this if you use us, you know, and I don't see this as a contract negotiation. So that was my question.
Okay, yeah, I mean, I was just going to leave it up to, you know, each county to figure out how they want to do that. But if that is too burdensome, we don't have to, you know, put that in there. I've never worked for a court before. I'm not entirely sure how all of those details work out.
This is Linda Byford. Is this not subject to bid through the counties that they're providing service for?
Well, it absolutely would be if a contract were required. This is Veronica Thornton. There are some counties that if you enter into a contract, then that has to be let out for bids. I think we're trying to make this a little more complicated than it needs to be. I think it should be left up to the county whether or not they want a contract with an individual company.
Okay. My understanding from the discussion is that the council would wish to strike this proposed rule. Is that correct?
Well, I guess we're discussing all of these now, and at some point, the rule changes that we adopted will be voted on as one. So I think what we're doing right now is we're not really discussing a motion. We're just talking with you and discussing the issue. So I don't think we need to vote on it.
Okay.
But Does anyone on the committee think that we should have written contracts between each court judge or courtroom or county and each entity? Does anyone feel like that's something that we need to do?
This is Linda Biter. I don't think we need anything between the individual judges, that sort of thing. But it looks like for the board and this council and to make sure everybody's on the same playing field, it would be easier to have a contract between the county and the probation service. But that once again, I'm like Ms. Thornton. I believe we need to leave that up to the county to make that decision.
This is John Hudson. I think we need to leave it up to the court to make the decision.
All right. Well, I know I could always say I'm not going to assign people to your company unless we have a contract if I wanted to. But I guess our question is whether or not we need to require it. And I'm kind of hearing that the committee's saying we don't need to require this as a rule for all counties. It's going to be up to the county and the company and the court.
That's my feeling on it.
I agree with you, Harvey. That's my feeling on it. Okay. All right. Well, why don't we then go on to the next item?
Okay.
Number E, I guess.
The next one that would be.
Is this okay? You're understanding our input, right?
Oh, yes, definitely.
Okay, good. Okay. Go ahead.
The next one would be subsection E. Maintain and have available for council, court, and probation reviewing the following. The schedule of fees, including a policy for indigent offenders, and proof of insurance and performance bond required under the next rule. I suggested this because in my research of private probation companies, a common criticism is overcharging probationers, and probationers don't know they're being overcharged because the schedule isn't available to them. And since we require a schedule anyway, I thought it would just prevent anything like that from happening if it's posted for view.
So this rule then would just be that what they're already required to have, that they have to have copies to give out on request.
Yes, or posted. I mean, it's not, however the council wants to do it, giving it out or posted or something like that, so probationers know whether they're being charged the right amount. And then so we can know if we have a complaint, we can go in and see, oh, this is what you're supposed to, but you're charging them more or not charging them, or it's an inconsistency.
All right. Well, obviously, if they have to furnish you, when I say furnish the council, means furnishing you a schedule of fees. And I understand they already have to furnish proof of insurance and performance bond. I guess my question is a policy for indigent offenders. I'm not sure that companies may want to put that in writing. It's almost like they've got an implied contract for that.
Okay, I included that because that is included in their application with us. They have to give us a policy. So I just saw that as part of the schedule of fees.
Okay.
If that's something that the council is worried about, I mean, that's open for discussion as well.
So everything in this rule they have to give you anyway in the application?
Yes, that's correct.
Right?
Nothing. There's no new requirements other than having it more available to the court and the probationers.
Okay. So this basically would say what they've already agreed to do with you, they just need to have that so if people request it, they can see it.
Yes.
Public notice.
Right, basically, upon request. I'm sorry, I'm monopolizing the questions here. Anyone else have any questions or comments, discussion?
This is Veronica Thornton. I think the rule is appropriate.
Is there any objection to the rule? No. All right. Well, you understand our input there. That seems to be fine.
Okay.
It would probably end up being D at some point, but that looks good to me.
All right.
All right.
The next one would be subsection F. Understand that it is responsible for the actions of all employees, agents, owners, independent contractors acting within the scope of their employment with the private entity. Again, this is something that's sort of applied or implied in civil courts, but a lot of other states have this written out in their rules just to give the private entity notice that if your employee does something egregious, we can still hold you responsible.
So if they contract out a drug school or something and those drug school people really do some bad things, that somebody can file a complaint against the company because of it?
Well, I'm not sure if a drug school would necessarily qualify as an employee.
Well, no, but I mean, it would be an independent contractor. In other words, if they, it's responsible action of employees, agents, owners, and independent contractors. So if they, if they are paying someone else to do something for them, I think they would be responsible for that person as well within a.
Yes.
Is that what you mean by independent contractor?
Well, when I wrote this, I was considering more some companies just hire people basically as employees and call them independent contractors. So my intent in writing that was to cover any potential situation like that, not necessarily a school.
All right. Are there any other questions about that rule or suggestions or objections?
This is Veronica Thornton again. I have somewhat of a problem with being responsible for the independent contractor. In my opinion, that means if you contract with a counseling service to provide counseling to your probationers, then you're responsible for what the counselors do. Is that correct?
Yeah, that's not what I intended when I wrote that, but I guess it could be construed that way. So maybe some redrafting would be appropriate.
Would you be comfortable just saying actions of all employees, agents, and owners?
Oh, yes, that would be
scope
fine.
of their employment.
Yeah, that sounds better.
Does anyone have an objection to excising the independent contractor?
No.
All right.
Okay. The next proposed change would be, I guess, at the bottom of page 2. It's mostly page 3. Rule 1177-2-.04, conflict of interest. And I would suggest adding code of professional conduct because I just used this section to include all of it. I thought about separating it out, but in terms, I'd have to renumber all the other rules, which is why my proposal just has it all in this one. Conflict of interest and unprofessional conduct.
All right.
So then the first addition would be number 4, no private entity that provides. Oh, sorry, never mind. Nicole caught me. Number 1 and number 2, I just added, and going along with the previous rule we discussed, I'd added on number 1 and number 2 to include employee, owner, or agent of the entity for giving anything of value to a governmental employee or employee's immediate family, or having personal business dealings with probationers under the entity's supervision. Again, this is something that's sort of implied based on how companies are in lawsuits, but just to make it clearer for the entity and everyone involved.
All right. Any objection? Okay.
Okay, and then the new addition would be number 4. And as you see, I kind of moved the original number 4 down to number 6 because I felt like 4 and 5 would be included in that. In the new number 6 kind of caveat. So that's kind of how I did that way. So if the council has any thoughts on that. Sorry. Okay, the new number 4 would be no private entity that provides probation services or employee, owner, or agent of the entity may accept or give a gift, gratuity, or favor from a probationer, a probationer's family, or any person who offers the gift, gratuity, or favor with the intent of influencing the supervision of a probationer.
Any objection? Okay.
And number 5 would be no private entity that provides probation services or employee, owner, or agent of the entity may solicit probationers for any product or service or direct probationers to attend a particular program provider unless the judge ordered the use of the particular product, service, or program provider. This does not prohibit furnishing a list of available programs or information about available programs to probationers. I included this one because a lot of other states have it. I have not had a situation where this has come up. So this is kind of a question mark one for me for discussion, whether you thought this was appropriate or not.
Ms. Thornton, what do you think about that? I guess my concern, and it doesn't really say that, is that if their probation company uses a particular provider, like for drug tests or anger management school or something like that, they would be directing them to use it, and it may not necessarily be ordered by name by the judge. But do you think that would cause a problem for the private company?
I think it could. Again, I think we're getting way too involved in the process of the agencies. For example, if you're in a small rural community, there may be only one provider that's going to conduct anger management classes or a DUI school or whatever. So, you would pretty much have to say, if you're going to comply with the court's order to go to anger management class, you have to go here.
I guess my suggestion would be that we not put this in unless it becomes a problem. If it becomes a problem and we have 2 or 3 providers in one county and a probation company is recommending one instead of another, and it becomes a problem, we might need to revisit that. But I'm not sure that that's something that...
Okay.
I don't think it's necessary at this point.
What's the feeling of other folks on the committee? The council, I mean. Anybody else?
I don't think it's, John Hudson, I don't see the necessity of it.
All right. Well, for right now, then, I think the committee, I keep saying committee, we're a council, I forget, that the council's view is probably this is not needed at this time.
All right.
But save the language if we may revisit it if it becomes a problem.
Right. Yeah, a lot of other states have it, which makes me think there probably has been a problem at some point, somewhere. I have not encountered it. My understanding is y'all haven't encountered it, so that is perfectly fine with me.
All right. Great. All right.
So the next one is number 7. No private entity that provides probation services or employee, owner, or agent of the entity may charge any fees not in the private entity's fee schedule unless ordered by a court or otherwise required by law. And this is just, it's already in the other rule we discussed. Just more clear, this will be a violation of unprofessional conduct if this happens.
Yeah, we had a company here in Memphis charging a non-reporting fee. So people would just not show up and they'd pay all 12 months ahead of time. So I don't like this rule, actually.
They can be pretty innovative. I think this rule is appropriate.
All right. Next.
Next one, this is number 8. No employees, owners, or agents of a private entity that provides probation services may engage in a romantic or sexual relationship or have any sexual contact with a probationer. No employees, owners, or agents of the private entity may use his or her supervisory position or influence to encourage, threaten, or force a probationer to engage in sexual activity. I drew this from the Department of Corrections rules, as well as a situation that I think y'all will remember from a prior legal report where a probationer felt extremely uncomfortable and felt like things the probation employee said were coercive and inappropriate.
Well, in state government, that's the fastest way to the unemployment line. This is what the well, it happened, but it's...
This is Veronica Thornton. I think the rule is appropriate. I can't imagine that an agency wouldn't already have a similar rule in place.
Hopefully no company will shut down because we passed this rule.
I hope not.
All right. Well, I'm not hearing any objections. All right.
Okay.
Next.
Next one is...
Mr. Chairman, yes, this is Stansel Ford.
Yes, sir.
I'm going to be conflicting to another meeting here pretty quick, and I just wondered if I come off, I won't mess the quorum up. Well,
I think we'll still have a quorum, just barely.
you still have a quorum.
Yes, sir.
I won't leave if you need me. I mean,
Well, we need you, but you can leave if you're needed somewhere else.
well, I'm sorry, but
Yes, sir.
I got another meeting scheduled here, but anyway, if that don't mess the quorum up, I'll see y'all the next meeting.
Thank you, sir. Yes, sir. See us or hear us, depending. All right, number 9.
All right, number 9. All employees, owners, or agents of the private entity must treat all members of the court and the probationers assigned to it in a professional manner. Professional treatment includes, or unprofessional treatment, includes but is not limited to, I guess we can go through each one. A would be engaging in abusive, aggressive, hostile, or disrespectful conduct towards probationers or members of the court.
We can just read all 5 if you don't
Read all
mind.
5? B, engaging in fraudulent or misleading behavior. C, giving any false impression of arrest authority through the use of his or her title or position with the private entity. D, collecting any money from probationers in excess of the private entity's fee schedule unless ordered by a court or otherwise required by law. And E, engaging in harassment or discrimination based on race, national origin, gender, age, sexual orientation, or ability to pay. And this is, I pulled this together based on the Department of Corrections, based on some issues I have encountered in my year with the council and, other standard guidelines.
All right. Anyone have any objection to any of those 5?
No, Your Honor.
All right. Thank you very much.
Okay. Then the next one would be the middle of page 4. Rule 1177-2-.06, refusal to renew, denial, suspension, or revocation of approval. I added 4 at the bottom. The first one would be number I. Again, it's already been said, but again, putting it in this rule for refusal to renew, denial, suspension, or revocation would be failure or refusal to follow its posted fee schedule.
All right.
And then J, I'm assuming we'll probably delete. Well, maybe not. Failure to follow its contract with the court. This would not require a contract. It would just be if there is one and you don't follow it.
Well, I think that would be something that the particular court would take care of already.
Okay.
I mean, if they didn't follow the contract, they would not get any business from that court, most likely. So I'm not sure that would be something that we would want to address. I'm not sure we would want to get involved in a contractual issue with the court. Unless someone else thinks we should have that in here.
I agree with you. I don't think it needs to be there. I can handle the probation.
Yeah.
All right. The next one, K, failure to follow the council's conflict of interest rules or code of conduct. And then the last one would be L, failure to properly supervise a probationer as set forth in the probation agreement. Failure to properly supervise includes but is not limited to not meeting with the probationer as required in the probation agreement, not conducting drug tests if required in the probation agreement, or not ensuring the probationer attends any counseling classes required. This one
mine says not tracking the probationer's sentence.
Oh, sorry, what does yours say?
Not tracking the probationer's attendance.
Okay, yes. No, I did change that because I didn't want it to seem like they had to show up and force them to go, which is why I thought maybe ensuring would be maybe a little easier.
Okay, so what is your new wording now?
Not ensuring the probationer attends any counseling classes required. This is something that may need to be redrafted. This came about in a situation did not rise to the level of formal complaint. Someone had alleged that this individual was put on probation, but since he was friends with someone, he didn't actually show up and they never supervised him, and they just said he was doing everything. So this is... Oh, sorry.
This is John Hudson. I think from a probation company standpoint, the insuring is probably worse than the tracking. Insuring suggests to me I'm going to see that they go. Tracking says I'm monitoring whether they go or not.
How about
I agree with you, Judge Hudson.
How about monitoring then?
Or well, suppose we said not ensuring the probationer has attended any counseling class. I just have a mental picture of someone kidnapping someone from their home and dragging them to the class. They can't force them to go, but they can tell us if they didn't go.
I like monitoring better. It seems a little broader to me.
I do too.
I like that. Also, as someone who does monitor folks going to class.
You can monitor whether or not they go. You can't ensure that they go.
That's right. Now, would it be better to say not monitoring the probationer's attendance or not monitoring that the probationer has attended?
I think attendance, it's a little less words, always better.
Okay. So would read not monitoring the probationer's attendance of any counseling classes required.
I think that's fine.
I do too.
Would you accept that as a friendly amendment?
Yes.
Okay.
All right.
Super.
All right, and then one final proposal for this document, the civil penalties, 2B, I just added conflict of interest and unprofessional conduct because it wasn't addressed in either of the categories. I picked category 2 because it was middle of the road. We can, decrease it or increase it at the council's will.
So basically, it makes it finable in 2B, category 2.
Right, and it would give it a range. So if you want the range to be more or less, we can switch the category. I just put it in the middle for discussion.
All right. Any discussion on whether that's a category 1, 2, or 3 violation?
I like the lot. This is John Hudson. I like her logic as category 2.
All right, I do too. Any other objection to having it there? All right. And I want to thank you for doing all this work too. It's going to make for a more ethical group of companies.
No problem. Just trying to address the problems we've encountered.
All right, now let's find the document that at the bottom it says page 1, January 2015 revised. The bottom left-hand corner. Anybody need any more time to find that document?
In my hand.
All right.
Okay. The first change, I believe, is at the bottom of page 3. This was an exemption rule that exempted certain counties with populations. I went through the 2010 census, and there are actually no counties that meet those population requirements anymore. I guess it was set in 2005.
Now, let me just say this. It's according to the 2010 census. So it doesn't change. In other words, whenever they're looking at those counties, they go back to what the population was in 2010.
Okay, I guess I'd understood the or any subsequent federal census to mean and going forward. But if that is not the case, then...
Right, we have that all the time. We have laws passed where constitutional, certain counties with this population. We have some in the code right now from the census back in, I think, 1970. And those laws still apply to that county because that's where they were. So if the county changes population, it doesn't necessarily mean that the law doesn't apply to that county anymore, but it could apply to other counties if they come in that range in a subsequent census.
Okay.
So like in 2020 would be the next census.
Mm-hmm.
Things might change.
Okay. Well,
If you understand what I mean?
Yes, that makes sense.
So you don't look at the population this year. You go back to the 2010 census, and then every year, every 10 years, they redo the statutes and change census numbers and figures.
Okay. Well, I had suggested repealing because no counties fell under that requirement, and if that is not the case, if I misunderstood that,
they still have the same number of people in 2010.
Right. Then I would take away that suggestion for repeal, since there are counties that would be affected unless the council has different thoughts.
I think we're okay there because they still, and those, and if you look at the code, those figures are published in the code from 2010 census, and they don't change. So.
All right. Moving on. Let's see. Where is the next one? It would be on the last page. We had discussed at the last meeting, I think Ms. Thornton had mentioned potentially lowering the quarterly provider fee. We are looking into that. We'd have to get some information from fiscal, just determine like how low we could have it and still, be in the black. So I don't have an answer for you at this point, but we are looking into the possibility of being able to potentially lower it. And then something else Ms. Thornton had suggested at the last meeting, I added in as number 2. The private entity shall not require probationers to pay their individual quarterly provider fees.
Now, where is that you've added?
A revised copy you didn't get us earlier. Okay, these are the 2 changes I've made, which we've quickly pointed out. I had added something in number 2. The private entity shall not require probationers to pay their individual quarterly provider fees. That was based on something Ms. Thornton had suggested at the last meeting, so I had remembered and then included it for discussion for the meeting today.
All right, so I'm still looking at page 6, quarterly provider fee, number 1. So you're adding a number 2?
Yes, based on Ms. Thornton's suggestion at the last meeting, that there was a problem or potential problem of just passing on that fee to the probationers and there was a fairness issue there, so I'd forgotten to include it, but I do want to bring it up for discussion.
All right. Well, let me just say before we ask Commissioner Bass that historically, when we first started, and gosh, I've been here since 1997 or 8, I think, when the legislation was passed. No one would show up. The Department of Commerce and Insurance didn't assign any staff, and it went on for several years. No one ever met or made any rules, and so the companies never started. And then I think we're in the red about $185,000 from work that your office had done and stuff. And so we wanted to catch all that back up, and so we made the fee $1 per probationer, and knowing that the probation companies would pay that, and they would get it from the probationer by charging their fees, and it was the will of the council at that time that once we caught up and had a surplus, that we would revisit that issue because it was punishing the probationers. And then we were thinking about revisiting that issue a couple of years ago, and somebody from the governor's office, no, it was somebody from the legislature, I think it was Speaker Ramsey, sent somebody over to say, it might have been Bill Giannini, to say, please don't change it right now. We're having fiscal problems. And I said, okay. And we never really addressed it. But we need to know we are building up a surplus, and we need to know if we should adjust that figure so that we pay our way but don't make a profit on the backs of people who are on probation. And that's kind of the history of that. So that's why we keep bringing that up from time to time.
I have raised the question. I have not yet gotten a definitive answer from, the fiscal department. That may take a little bit to look into, but I had begun looking into it again since we are proposing rule changes at this point.
Okay, and I'll work on that. I'll work with the accounting staff on the reserve balance and whether or not we can lower the licensing fees.
And as I'm understanding, the legislature does have to pass these rule changes, do they not?
Once we file the rules with the Secretary of State, once we've approved them completely and they've left our department, the legislature, the Government Ops Committee does have a final say over them. They can approve them and it goes through fine. If they don't approve them, They would be effective until, I guess, next June. They would take it out of the omnibus bill, if I'm remembering correctly. But the Government Ops Committee in the legislature does have the final say, but it is, you know, after we've filed it with the Secretary of State.
Because there will be a fiscal note to lowering the fee.
Yes.
And of course that will flag it for the legislature, so we need to consider that too. But,
so we hope to have...
Judge Kraft,
yes?
this is Veronica. I think there may have been some misunderstanding. We talked about number 2 on page 6. Of course, I don't have anything on my sheet here about a number 2. But, you know, as far as passing the quarterly provider fee expense on to the probationer, I think that's appropriate because the agency is the only source of revenue is the supervision fee. So that's obviously where they're going to get the money. The agencies are going to get the money to pay the quarterly provider fee.
Right.
Okay, I must have misunderstood in the discussion about lowering the fees. So I apologize for that.
Right. No, that's okay. In the situation, just so you understand, since you're new at this, and some of us have been riding this horse for a long time, is that the private probation companies, they make their money and they survive on fees paid by the probationers. Mm-hmm. Some of the probationers don't have any money, and a lot of the private probation companies, they just serve them because they want the courts to be happy and out of the goodness of their heart, and they make that up from other fees. But regardless, every company has to pay $1 every quarter for each person they've supervised. Even the people that don't show up and never pay $1 and get violated, they have to pay that $1. And so eventually, it's like when people are talking about minimum wage at Walmart, you know, when they raise the minimum wage, Walmart is not paying the extra money. We are when we buy stuff at Walmart because they're going to raise their prices. And it's the same thing with the probationers. They're really going to pay it in a way because the probation companies are going to pass that along to them. But it's our desire at some point to lower that $1 if we're making more money than we need to run the council. To lower that $1, it doesn't sound like much money to a probationer, but when you're talking about a private company with a lot of probationers, it's a lot of money to them, and they have to make that up through fees for the probationers. So that's our issue is not really not making the probationer pay it because, I mean, no one else can pay it. I mean, it's got to be money coming from probationers. But to lower so that if a probation company is supervising 900 folks, they got to pay $900 every quarter, and if that's lowered, then they don't have to. They can work with more probationers without having to make up for that difference. Probationers that are hurting financially, if that makes sense. Anybody else from the council wants to add on to that? Okay. But that's our situation. So we know that indirectly, I mean, we know that the probation companies are paying it each quarter, but they're getting their money from the probationers, and there's no way that money can't come from anywhere else.
Right.
You know, so that's our situation.
Okay.
So
Yeah,
I'm not sure that we need a number 2. But if we can lower that $1 to 50 cents, I mean, at first we were thinking about a quarter, and then we were figuring 50 cents, and then at some point, because we were still in the red, we wanted to catch up, so we made it $1. And in those minutes of those meetings, if you look back at our meeting minutes, it'll say that, but we don't want to keep it at $1. Once we get caught up and build up a surplus that we can work on, we would like to cut that back because that would help the private probation companies, and they in turn could help more probationers who are having a hard time paying.
Judge Kraft?
Yes.
This is Veronica again. I've only been on the council for 5 years, but we've been talking about lowering the fee for 5 years.
That's right. Once we got out of the red, we operated in the red for about 6 years, paying things off, and then the state had a fiscal problem several years ago.
Mm-hmm. If they find out you're sitting on this much money, they're gonna attach it.
Right. So what the council I think wants to do is to figure out what is our actual costs, and it's not that we want to give this money away to someone else. But if we could only take in what we need, then I think that would be best, instead of trying to balance in the Tennessee state budget on the back of people who, if they had a lot of money, probably wouldn't have committed the crime in the first place.
All right, we'll look into that and hopefully have an answer to you at the next meeting.
So I take it that the will of the council is not to make a change to quarterly provider fee on page 6.
Correct.
Okay.
That gives me some good direction to go on. Thank you.
Yes, ma'am. Thank you.
All right, that is the end of all my changes,
All right.
rules for discussion.
Now we have budget report.
Actually,
Savers?
just to follow up, moving forward, my plan is to get with Nicole to figure out the provider fee and then present a more finalized draft based on your comments at the next meeting. And then if the council wishes to go forward, we would then have a rulemaking hearing, which I guess would be in 2 meetings from now, if that timeline works for the council. And then we would proceed forward if the council wishes to do so.
That's, you don't need a motion.
No, that's
motion.
just
Okay.
that's just where this is going.
Does anyone object to that or want to change that timeline? No, I think that sounds fine.
Okay, and then if all goes according to plan, we would have a rulemaking hearing in December. And so I believe that would probably need to be a physical meeting where everyone would need to come to Nashville. So if that is a problem, let us know.
Well, as long as we know ahead of time, it's not. So that's great.
Well, if you can tentatively plan that for now, and then we'll probably know for sure in September.
All right. Thank you.
All right. Well, with the chairman's permission, I will give you the director's report, and then everyone can go on to today's business.
All right. Budget report.
All right.
So we were just talking about.
The budget report is included on the director's report for your review. The budget plan shows at the bottom of the first page of the director's report, which is a proposal of $37,900. The total expenditures as of April 30th, 2015 is currently $13,669, and the revenue generated thus far this year is $100,108. I've also put some license numbers together for you. We have active licensees of 39, one on the complaint report, which you've already heard. I put together a summary of my introduction for you because I knew you'd read the board documents before you got here today. If you have any questions for me, certainly I'm glad to answer them. And I know Kimberly gave these to you at the last meeting, but if you hadn't turned in your conflict of interest forms, please email those to me.
If you do not have one from one of us, would you email us and tell us?
I haven't gotten everything from Kimberly yet, so
I understand, but I mean, I most likely signed mine and emailed it in, but I don't have a record of whether I did or not. So
Okay.
I was just wondering if you once everything settles out and you've moved in, so to speak.
Okay.
If you could let us know if you don't have a conflict of interest, let individually just let them know, then they can send it in.
All right, will do.
Okay. Any questions about the budget from the council? All right. Thank you.
There's no legislative updates this month, and that concludes the director's report.
All right. Now, complaint performance measure update. What does that mean? I have that on the agenda, but what exactly is that?
Well, we only had one complaint open currently, and it was closed today, so
Okay.
that's...
Sounds like you're 100% effective so far.
The complaint performance measure is an internal measure we use to make sure we're processing all complaints in a timely manner. Since we had one and it's closed, there's not much to report.
All right. So for our next meeting, whatever complaints we have and everything, we're going to get 2 sets of minutes. We'll get the minutes from this meeting and also the March meeting to approve for the
Correct.
next meeting. And we'll get some rules that we can vote up or down on.
All
Okay.
right, sounds good.
Any other new business? I want to thank y'all very much for showing up on a Friday morning on the phone. Thank y'all very much for your cooperation. And we'll see you guys. We'll either hear from you guys or see you guys in September, all right? So we'll show the council meeting adjourned.
Thank you, everyone.
Thank you. Very well.
Good evening. Bye-bye.
Good evening.
Bye.